You're welcome back. This is Newsfile. It's your most authoritative news analysis platform. And here on Newsfile, we put Ghana First. It's brought to you by Bekande sponsorship of Bank of Africa. Strong as a group, close as a partner, MTN, everywhere you go. Ashesi University, educating ethical and entrepreneurial leaders for Africa. Robert and Sons Optical Services, your comprehensive eye care service provider for 33 plus years. My Way Insurance. Dial star 165 hash on MTN to join My Way today. Syntax tanks. It's strong, it's tough. Activa International Insurance. Our clients are passion. International Facilities Management Association. They are proud to be associated with your most authoritative news analysis platform, Newsfile, and Safari Valley Eco Park, bringing you closer to nature. Now, on the 1st of September 2025, we had a release from the presidency under the hand of Felix Kwakye Ofosu, MP spokesperson to the president and Minister Government Communications, and it said that the President John Dramani Mahama has, in accordance with Article 1469 of the 1992 Constitution, removed Chief Justice, Lady Chief Justice Gertrude Arabai Saba Saki Tokonu from office with immediate effect. This follows receipt of the report of the committee constituted under Article 1466 to inquire into a petition submitted by a Ghanaian citizen, Mr. David Ofori. After considering the petition and the evidence, the committee found that the grounds of stated misbehavior under Article 1461 had been established and recommended her removal from office. Under Article 1469, the President is required to act in accordance with the committee's recommendations. And soon after that, we began to intercept letters, or a letter, also dated the same day, and it is notification of removal from office. Ladyship Gertrude Arabai Sabasaki Tokonu, Chief Justice of the Republic of Ghana, and it is signed by Callistus Mahama, who is Secretary to the President, and then subsequently there is also, a fiat or a warrant to that effect, announcing that the Chief Justice has been removed. And in that letter, it states the grounds on which the committee found that she could no longer continue in office as the Chief Justice. Right. So let's begin to ask the questions about what has happened, and we are very, very, very privileged to be joined by two of the lawyers who were involved in the petitions. You know, there were three of them. Two of the lawyers were involved. Aiko Otu was leading the former Chief Justice's legal team. Oliver Bakavomowo was also with one of the petitioners. We have Mami Mensah Bonsu joining us now. Mami, thank you very much for making time to join us.
Thank you for having me.
Great, great, great. We are very excited to have you. Mami is a constitutional theorist. She's Associate of Law and Head of Department of Law and Public Policy at Ashesi. They're doing something very, very, very important at Ashesi University. As far as the teaching of law is concerned, I had the privilege to be at the department recently, and they are teaching law with ethics in a way that makes the lawyer well-rounded. Now, I'd like to begin with Aiko Otu, because he has, shortly after the news came up, expressed surprise about the fact that the committee had finished its work and submitted a report and the Chief Justice was gone. Why were you surprised about the turn of events?
Now, if you followed the program as you had told us, I did mention that Oliver Vomawo's group were the next that we were to take. That is what they call the shining stars or so. Now, on that day, they wrote a letter to say that they would not be available because Oliver himself, according to him, was having medical issues, and some of his people who would testify were equally having medical issues. So they wanted a very long adjournment. The committee therefore adjourned the case to the 15th, the hearing to the 15th of September for us to come and start. On the same day, we made it clear to them, that is the day before we had written to say that they gave us only about 5 days and that we needed a little more time, 1 week, to run up. We had even raised the issue that asking both parties to file their addresses simultaneously was not the best in view of the fact that there were petitioners who are alleging wrongdoing on the part of the Chief Justice, and therefore they should have the option to tell us how they have seen this thing right from the beginning for us to respond. The committee said, no, we should still keep to what they have said. And then they told us that, look, after all, if they ask us to file it by a certain date and we have not finished, we could file it within a reasonable time. It's not by force that we should meet it by all means, but we should file it within a reasonable time. That was 25th or so. That was when we were talking. So we took the 1 week and we were about to file it on the following Monday, only to be told that the report had already been issued. If you followed me on the PM Express, I also made the point that I didn't know that Chachu and his people had even filed their submissions because we were not saved. It is this morning that you started reading from it that I was taken aback and said, what is happening? You even have a copy of what they filed. So, like I said, where is the fairness? They didn't even wait for us to file whatever. They did not say that if you don't file it by a certain date, we will take it that you are no longer interested in filing. But they just went ahead, apparently having prepared whatever they wanted to prepare, and went and submitted it based upon one-sided, submission. From what you are telling me now, these were the things that Chachu told them. What about our side? So they didn't want to hear what we wanted to say.
Okay, so let's get to learn about the facts. You were giving the 25th of August.
That is 5 days.
To file your written submissions, right?
Yes, yes.
By 25th, you had not filed.
We had not, because we were preparing to start the Shining Stars 2 at the same time.
But the petitioner, as in Daniel Ofori and his lawyers, had filed by 25th.
Nobody told us anything. Nobody. That's what I'm saying. I'm hearing it from you for the first time, because they told us we could file it within a reasonable time.
But you were giving 25th.
Adjourned the hearings to the 15th of September.
But you had just confirmed to me a while ago that you were giving the 25th to file.
Have I denied that?
Right. So as I
we were giving.
Okay, please, I'm informing you.
I don't want this kind of.
No, we are doing just a bit of a fact.
Creating the impression as if I'm telling lies.
No, I'm not suggesting. I won't do that. I won't do that, sir. So I'm saying that on the 25th, the petitioner had filed their written submissions. They filed it on the 25th because that was the deadline you were giving, but you were unable to meet the deadline.
I'm saying to you that they said we should file it by the 25th. 24th, we wrote to them that we were on it, we would not be able to complete, and we needed 1 week.
Okay.
That was the day that Oliver Vomawo's group were also to start theirs. And we said, look, we are settled with 2 of them. One to write the submission, at the same time prepare to come and meet the Oliver Vomawa people, Shining Stars. So could we be giving 1 week to organize ourselves, file the written submission, and then start the hearing? Okay. And they told us that day, because it did not involve Chachuchikata and his group, they were not there. So what they would tell us is that they would give us an advice that we should try and file it within a reasonable period. That is all.
Okay.
And then the entire trial was then adjourned to the 15th to give Shining Stars, their lawyer, and whoever will come sufficient time to come back. What is today's date?
Right. So, as I understand, you also were surprised that the committee had come up with a report on one petition when your expectation was that they would wait for the whole, all the petitions to be gone into before they present, as it were, a composite and one address or one report.
Oliver Vomawa was there on the first day when they tried to agree on the procedures they were going to adopt. And he would tell you that what they said was that they had 3 petitions. They would start with Daniel Ofori and adjourn the 2 Sanadai. When they are ready, they will call us, give us hearing notices to come, and then we go on with the other ones. So they were only going to start with Daniel Ofori. In the course of time, we received a hearing notice to appear to talk about issues being raised by Shining Stars. And I raised the objection that we are not finished with one, which you said you wanted to do. Why are you now moving on to deal with these ones? He said, oh, these are just preliminary matters because they have indicated they wanted to call so many people, to subpoena so many people, and they wanted to talk to them to let them know how these subpoenas are done. Ask him, he was there with us, for example, that day. He had not always been with us because we have only been with Daniel Ofori. So he was there the first day. Then he came again for these preliminary matters to be dealt with, and that was it. I don't remember that he sat through, and he can tell you what took place. I sat through and started the cross-examination from day 1 in December. On the Wednesday of May or so.
When you were agreeing on the procedure to be adopted, where the committee announced to you that they were going to use the CI 47, the High Court rules. They were going to use the High Court rules, as it were, and adopt it. And the High Court rules, and with necessary modifications where necessary. They had also announced to you, as in all of you, the lawyers and the parties in the room, that, quote, the trial will be petition by petition. Each of the 3 will be tried separately, end quote. Is that what you were told?
I wasn't there on the first day. It was my colleague Edu Kusi, who was present. But I read the proceedings for that day.
Okay.
And I'm saying that they told them that if you have a copy, read the entire thing and see whether you will not find them saying that they are going to adjourn the 2 Sanadai and call us when they are ready. Find out whether it was not agreed upon on that first day.
All right. So hold on briefly for me. I'll return to you. We'll deal with the substance. Now, what do you know? Because there was the suggestion of a surprise at the submission of a report for Daniel Ofori's, petition, which had been finished. I had to try and find out what the facts were. And that's what I just quoted, where the committee said at the very beginning, when the procedure was being adopted, the committee said, quote, the trial will be petition by petition. Each of the 3 will be tried separately, end quote.
No, thank you very much, Samson. In fact, going into this on the first day, I think that the natural assumption of all of us was that the petitions were going to be handled together and that, we will go sequentially as it was necessary to. Now, in terms of setting the procedures, it became clear that the committee's view was that we're going to bifurcate the process in dealing with. And that the first time that we met was because there were common procedural issues that would affect all the petitions, then we would take all of them together. In fact, it was during the beginnings, and this later on became a subject of controversy when the former Chief Justice made the press conference as to whether or not her lawyers were given hearing. Because when Mr. Dukusi came before the committee on that day, he said that he was not there representing the Chief Justice. But he was there because he had been informed to come and investigate whether this is truly a committee. That was his position on that day. And so we went in through, and the record will show that, in fact, we went in through whether or not the respondent had been served with the process. In fact, there had been exchanges.
But on that day you just mentioned,
on that day,
he sat through.
He sat through.
Correct.
In fact, I objected to his presence there because I said that if clearly he's claiming that he's not representing in a legal capacity, then his presence would pierce the in-camera nature of the proceedings. That was my position. Senior Chachukata took a different position on it. The committee deliberated and decided that they would allow him to proceed because we were not going into the substance of the matter and we were only dealing with procedural issues at that point. So all of us were clear when we were leaving there that the petitions were going to be treated separately and individually on their own. There was no conversation as to whether or not a holistic report would be written in respect of all three. And in fact, if a position would have been taken to write a holistic report on all three, it would have been inconsistent with the idea to treat them as separate petitions. Now, again, I would say that it was not clear to any of us.
But in court, cases can be consolidated.
The cases can be consolidated.
And when they are consolidated, they still are tried in their individual cases.
Yes.
And so...
Yeah. No, so yes, I'll come to that. So at no point did we leave, in fact, with any direction, that the report of the committee was going to be one, wholly, or separate. Also, there was no direction and indication from us to understand whether they were going to be transmitted separately or they were going to be transmitted together, even if the decision was taken to write them separately. There was no understanding from any of us that if it was separated, whatever conclusions that were reached, the president was going to act or not act separately, serially, or sequentially. None of those were clarified. And in fact, it goes again into what we say the consistent developing practice around 146 itself, whether or not, and every time we get into this, it's like going into a new process altogether, to be honest. And perhaps I'll come back more substantively to those points. But as far as the first day initial was concerned, it was clear to all of us that this was how it was going to happen. Now, mind you, despite this, even as the first hearings were going on, we had intervened, I think, 3 times. The first there's a petition, this that was pending before the committee that we had brought, asking that the committee recommend to the Attorney General for certain persons to be held in contempt. Because we, first of all, took the view that we didn't think that the committee had the power to punish for contempt, and that if anything, they can make a recommendation to the Attorney General for that. So we brought that in a complaint therein. And subsequently, we brought the subpoena, listed a number of people and a number of documents that we're going after. Now, there was a lack of clarity as to whether or not each of the subpoena and each of the documents that we required needed to be individual, or that we can put them together as one and request all the documents that we're requiring for. And then again, we met the committee, and the committee's direction was that they wanted each person to be dealt with individually. Now, we understood the committee's reasoning that because, again, of the in-camera nature of the proceedings, each witness should not have a sense or idea of which other witnesses were appearing and which other documents were being requested in the matter, which we took to be understood to be fair. And I think the last instance that we appeared again was in respect of when the committee had summoned us as to when to begin the process of this. And where we then indicated to the committee that for medical reasons, we're asking for the dates to be changed. But the reason why this is important because the second time we appeared before the committee, we had a different understanding that we were going to start almost immediately in 2 days. That did not happen. It took about 3 weeks. And so then, because of I imagine that other issues which had appeared in dealing with the first petition, the timeline that we were supposed to appear had shifted, which meant that other accommodations needed to be arrived at. And so it was clear to us, and when we were informed, in fact, we had a conversation with the third petitioner, and we had written to the registrar that if the third petitioner was ready to go, they could take the third petitioner even before us. The third petitioner reached out and said that his understanding was that the committee wanted to continue sequentially, so they would still take the second before they take the third. So that was the conversations. Again, the report was made to the president.
So this question substantively to you and to Inusa, will it not be tidier that even when you consolidate cases, 2-3 cases together, the law is that even though consolidated, they will be tried separately.
Yeah.
But once they are done, because the facts in one case affects the other, it is the reason you consolidate them. Once you are done, the judges will normally perhaps give one lead judgment. Then the others, they may give a small, brief judgment and refer to other matters. Will it not have been tidier to wait to finish all of the petitions and then render the decisions, even though separately?
You know what, to be fair, the first point I'll start with is, I, for instance, had a problem with bifurcation. I'll come to reason.
Is this a bifurcation or a trifurcation?
A trifurcation of the petition in many respects. Because one, there were certain documents and things that had been solicited and obtained in the first petition, which were relevant to the second petition. Now, we internally had to debate whether or not because they're not part of the record, essentially, as regards to us, do we have to then subpoena those matters as well? What does that augur for the length of the process and the speedy nature of which we have to deal with this? So in my opinion, because of, again, the law, because we have taken a technical nature to how we are dealing with this, more than we should, in my opinion, that it creates then those evidentiary questions as to what is part of the evidence and what is not part and not to be excluded. But I do sincerely believe that, in fact, when I saw that the committee had reported to the president, my feeling at the time was that perhaps I don't know what the substance was, the president was going to wait and hear the petition that he himself had referred for a committee to listen to before a decision would be taken in respect of it, irrespective of what the decision was. So that was my feeling. So again, it is surprising to me that a decision has been made in connection with the Chief Justice, because now we're asking ourselves, we cannot move against a suspended Chief Justice. I mean, in fact, the nature of the person before the respondent has changed. And our petition was against a sitting Chief Justice. So we don't even know whether technically in law, these petitions, the second and the third, are still viable. There's also the Supreme Court decision in Ansuji Abuo, where the Supreme Court is saying that if the person is retired, you can't bring proceedings against them. So the person is no longer there. So I don't even think that this can continue as they are. So my feeling was that if in whatever the decision that the committee took to report on the first and in fact they did inform the president that they were going to hear the second, that I think that the presidency should have waited and gotten the full benefit of everything before the procedures. And whatever the case may be, it hasn't happened now. Hopefully in a way in which in 1992 when we decided to separate the presidential elections and the parliamentary elections and the MPP then boycotted the second, we then later on decided that we're going to hold both on the same day, that it might inform subsequent proceedings, that this is how we're going to move on them. But in my opinion, I think that perhaps a more tidier thing would have been, one, to report on them holistically, or two, that the president, having received the one, should have waited for the others.
Okay. Minister, I'm asking you the same question.
I think that...
Would it not have been best or better?
I think that Oliver has said something which is very poignant and fundamental to this process. That anytime you are hearing Article 146 matter, it looks like you are going into a new process altogether. And it's part of the learning curve. You know the case of Loretta Lamte. There were two petitions. How was it dealt with?
So I've heard this repeated,
yes,
that there were two petitions.
Yes.
There were more than two petitions.
Okay.
There was one petition that carried the day, and that's the petition I prosecuted.
Yes.
Right.
Good. Now, so how was it? Did they take all the petitions together? Or they looked at the petition that raised the prima facie?
It was only one petition. That of my client made the threshold for prima facie.
Yes.
So when we went into the process, it was just my client and the respondent. That's all.
That's all.
That's all.
So that's what happened in the Loretta Lamte case. In the Charlotte Osei case, there were two petitions or more. How did they go about the process? Now, I'm asking these questions not because I need answers. I'm asking these questions because when Vomo and others were part of the Constitution Review Committee, they recommended in paragraph 2020 that a court, the Rules of Court Committee must develop rules and procedures, rules of procedure to guide how the committee itself works.
Long before that.
Long before
they
that.
did this work in 2010, 2011, and 12.
Yes.
Long before that, in 2005, Sophia Kufu in a J-Chum insisted that there have to be rules.
Rules,
yeah.
Of course. Now, so the absence of the rules of court, rules regulating how the committee goes about its work, how the committee deals with multiple petitions, whether or not the true intendment of the matter is when a petition establishes a prima facie and then goes ahead to establish the culpability of the party being investigated. That itself is enough. You don't know. So you are always in the state of flux. Things are moving. And you can only rely on experiences that are coming out to see how we shape the law to bring certainty to the whole process.
Isn't that an unnecessary confusion? Because the Committee of Inquiry rules, which were made in 2010, which the Chief Justice was insisting should be what should be used. But except that in those rules, it was specific that it was pursuant to Article 28 something, Commission of Inquiry
rules, yes,
and not about Article 146. But even in those rules, it also says that the High Court Civil Procedure rules will be adopted. And this committee said, whilst they are not using those rules, they are taking guidance from those rules to use the High Court Civil Procedure rules with the necessary modification. So if you use the High Court Civil Procedure rules, you shouldn't be groping in the dark. It sets out how you should deal with cases.
So it says, it sets out how to deal with cases. But you just heard Vomo. And in fact, that's my confusion as well. So the Constitution itself starts from the premise that the whole jurisdiction or authority of the president is invoked by a petition. Now, so if a court, a committee established under Article 146 receives multiple petitions, and one petition, which they have looked into, establishes a prima facie, and they sit on that petition, and that petition establishes culpability, do they need to go to the other petitions? Do they need to? We don't know. Vomo says, to all intents and purposes, when you look at the decisions of the Supreme Court, the Chief Justice has been removed from office. Can you proceed against her now?
The committee, at the very beginning, when it was setting out the ground rules, says we have 3 petitions. We are going to deal with each separately.
Yes.
It didn't say we'll deal with one, and that one will undo the others.
Yeah, I agree with you. They said they were going to deal with it. We are hearing what transpired at the committee level from those who were in the committee or who were in at the sittings. What I'm saying is that when a committee says we are going to deal with petitions individually and serially, what does it mean? They listen, they deal with that petition, take evidence, conclude and submit a report, or what does it mean? So this is part of the confusion.
So even though they use the High Court Civil Procedure rules, they said they were using it with necessary modifications. So their modification is that we'll not wait to finish the 3. When we finish one, we'll do a report on one and submit, then continue.
Exactly.
So are you expecting them to continue with the 2 petitions?
I'm not. Because it will be moot. It's moot. That's my candid opinion. It's moot.
So is it fair? Because in those petitions, she could have raised other defenses in there that may have impacted on the first petition.
So how does it go to, now that they produce a report, and that report has found her culpable, Shine and the other petitions, if they exculpate her, how does it operate to reverse the decision in the Daniel says case?
Interesting. Now, hold on with that. And I want us to clear this quickly before we continue with the substance of the grounds of stated misbehavior and how they have and what they have ended in against what Justice Sofia Akufo has been saying. Now, Naneje, so what would have been your preference? And is there an injustice or is there an unfairness that has been done as a result of this approach? First, not waiting to receive the written address, as it were, the final arguments of the respondent, the Chief Justice's lawyers, to factor it in their decision making, regardless of the fact that they didn't meet the deadline. But a day before, as Aikutu says, they wrote to the committee to say, we are unable to meet the deadline. Can you give us extra time? And we all do this in the courtroom, right?
Yes, my brother. Thank you very much. But I want to confirm one thing. Where was the committee given a timeline within which to operate? Can we confirm that?
We don't know about that, and generally Article 146 does not provide timelines. Perhaps that is the reason when you were passing the Special Office of Special Prosecutor Act in 2017, you put in there that there should be timelines, so everything is time-bound.
So in the absence of timelines, what was the committee in a hurry for? Why the rush? Particularly because you have two other petitions, so to speak, quote unquote, and our address all those pending before you. Why? Who was putting pressure on you to achieve what? When you are dealing with a matter as important as the removal of the Chief Justice of the Republic of the land. Why were you in a hurry to present your report on just one of the petitions, right, which in your view would then dispose of all the matters and will make other petitions redundant? Couldn't you have taken your time to receive the address or submission of the Chief Justice? Doesn't fairness dictate it? I thought that this is not a commission of inquiry. Right? It's also not, even though you are using CI 47, even with CI 47, Thompson, how many times doesn't the court adjourn just to take our addresses? The court adjourns on many occasions. Sometimes, even when the court has fixed the date for parties to file their addresses, you can come in with an application that may impact the filing of the address. And so the court, in hearing the application or having disposed of the application, will give a new date to the address. And so even under the CI 47, there is always enough room for the court to entertain such request for adjournment to receive or to file addresses.
But that's obviously discretionary, right?
Yes, but I would think that when you are dealing with a matter of this nature, you should be predisposed to a lot of laxity to accommodate, the Chief Justice, particularly given the sensitivity of the matter that we were dealing with, the sensitive nature of the matter which they were dealing with.
You think 6 months, we've been at it for almost 6 months now, is it? You think that's too short when you say they are in a hurry?
I haven't said that the time is too short or too long. I'm saying that in the specific reference to the reception of the address, if a request that comes and is unreasonable, particularly given the feedback that we have received from Mr. Aikuotu, right, to rush to file, present your report, for me, is very, very, very unfortunate.
What would you say to those who say, well, if you take the issue or your case as seriously as you ought to, you shouldn't be found wanting, to meet a deadline. You should actually work to beat the deadline.
My brother, given the gamut of evidence that have been disclosed to have been produced before the committee, given the number of witnesses, I think that it will be. It's not something which is not expected. It's expected that lawyers or barristers will always ask for extension of time in the circumstance of this nature, particularly also given the grievous nature of the matter at hand. Look, this is a matter involving the removal of the Chief Justice.
In fact, the committee said that they received about 10,000 pages of documentary exhibits from both sides.
So, if somebody asks for extension of time, I don't think it is out of place. But something.
But does it also matter, or it doesn't matter to you, that when you file such addresses, according to law, the address is actually not mandatory, and whatever you put in the address is not also binding on the judges?
It aids the court in coming to its decision.
That's right.
And if it was not necessary, we would have scrapped it. It is put there to tell you that if you don't file, the court can go ahead to make a decision. However, given the controversial nature of this matter, you want to put it beyond reproach, beyond blemish. As it stands now, it's one of the things that we are going to point to as contributing to the injustice or the unfairness of the process. Look, my brother, the other issue that you raised pertaining to why the committee presented a report on one of the petitions instead of completing with the hearing in respect of the two other petitions. In my view, the failure to do that has not only rendered an unfairness or injustice to the parties that filed the petition, but the Chief Justice, because those allegations will continue to hang around her neck without having the opportunity to prove that they were not true. And so this approach by the committee has also unfairly versed the...
So a very quick one before I go to Mame Mensah Bonsu. Yes, they had 13 witnesses for one side, 12 witnesses for the other side. They had 10,000 documentary exhibits altogether, which makes it a lot. I can't imagine myself as a lawyer having to go through such load to write, an address. But some will argue that sometimes you and I know by our practice, as the case is going on, you should be gathering your address. You will be getting each of the record of proceedings. After the close of each day, you get a record, and then you start writing bit by bit and so on and so forth. But my substantive question is this. How do these two events, not waiting or granting an extension of time to receive the address, to use it to factor into their decision, and also presenting a separate decision, how do these change call them the admitted facts? So that, for example, on the travel expense, the Chief Justice does not deny that this happened, that she took the money, that she went with the husband, that she went with the daughter, and that per diems were paid, and that she retired unimpressed of 6,000 plus or so. If the decision is that this was wrong, this was unlawful, this was unconstitutional, how does giving extra time or presenting a composite report change it?
Whether or not it is wrong is one level, and it is distinct from whether or not it meets the constitutional threshold for the removal of the CJ under Article 146 of 146(1) of the Constitution. They are two distinct. We need to appreciate that not every error or, if you like, offense or happening may meet that constitutional threshold. Otherwise, every flimsy thing may lead to the removal of the Chief Justice. Doesn't it? You see, this whole matter, we are talking about, I hear Oliver make reference to petition. This is where the error started from. The error started from the wrong foundation. The president receives a petition.
Okay, Nana,
but the president,
please pardon me. Please pardon me. Hold on. I want to do something. No, hold on. We'll go there shortly. Mami, I want you to bring your view on these two preliminary issues as after the report has been presented. Whether the not waiting for or giving an extension of time for them to file their address, and also presenting a separate report for Daniel Ofori's petition, which actually contained the most charges. What difference does it make, and how would you say that doesn't make things tidier?
Thank you, Samson. I think I want to start by saying that in pure terms of technical effect, the committee did nothing wrong. It doesn't affect the legality of it in any way, that they did not grant an extension or that they did not send a consolidated report, because they are separate petitions which require separate conclusions. And while it may have been nice to have had all three together, there is nothing by way of error in them not choosing to do so. However, I'm going to have to agree with Nana Ajebua for that. The refusal to grant the extension was neither necessary nor prudent. I think, given the gravity of the situation and the gravity of its outcome, it was important for there to be no procedural doubts around it, to the extent possible, because as Honorable Hussaini pointed out, we are always within a new space with untried, constitutional provisions. So their errors are bound to be made, but there are avoidable errors. And I think granting them, we've been 6 months down this road. I think one more week would not have hurt. That said, I don't think it actually invalidates anything. I just think it creates an unnecessary, if you like, noise around the committee's work, which it could have spared itself simply by giving them a week. As to the decision to send them individually, if I send a petition, I'm not quite sure why I should have to wait till somebody else's petition has been heard before I know what the outcome of mine is. So I can't fault that. The president's decision to act on the recommendations of that particular petition, as opposed to wait for the rest, again, it was a choice, but he was bound by the recommendation of that particular petition. So whether he waited or he didn't wait, he would have ended up doing the same thing, because he was bound. He is bound by the recommendations. It's not a discretionary choice to accept, or he can't issue a white paper saying he thinks they've done a good job, but he's going to caution her and let her go, or whatever. He was bound, and therefore the decision to act, I think people are entitled to their opinions whether he should have waited or not. Was it necessary for him to wait? I don't think so. The process, and I do take Nana Jabafu's point that the charges in the other petitions remain unresolved, and so she hasn't had a chance to prove her innocence. However, those petitions are supposed to be secret anyway. So if everybody had been doing their part in this journey, nobody leaking documents, and everybody respecting the constitutional provision on secrecy, then the unresolved nature of the petitions should not really affect the reputation of the respondent. The problem is that people haven't. But if everybody had done so, it should not matter. As a matter of public funds, this committee is sitting on public funds. They have heard one petition. They have heard it to its end. They have come to a conclusion on it. Their conclusion leads to a single position in law. They have sent the report on to the president. I'm not sure that the cost of public funds to continue the process, given that its conclusion was now set in stone once the committee's recommendations in Daniel Ofori were made, is justified. I do admit that if they had finished, at least we'd have a historical record. But I don't know that I would say that would justify the cost of the public purse. So
you are saying the chairman of the committee, Justice Gabriel Scott Portman, ended his speech to the president by saying, accordingly, we shall be reporting on the second and third petitions in due time. You are saying that this has become otiose, we can't get to them anymore, it's waste of public funds if we go to them?
I think we can decide to carry on, but as Oliver points out, you are dealing with the removal of a chief justice, a petition to remove a chief justice who is no longer chief justice. So supposing we go through the process and we get to the end and the recommendation is that she should be removed, what action will the president take now? Oh. So then it will be a long and expensive process, so we know that she should have been removed 3 times, or she should have been removed only once, or twice she would have been removed. But so I'm not sure that there's any value to continuing it. Right. I think Justice Parman was correct to state that they would, they finished with petition 1. They have petition 2. They were charged to listen to 3 petitions because they don't remove the Chief Justice. That's not the committee's job. The committee's job is to hear the petitions and decide whether they meet the constitutional thresholds for removal and recommend same. That's their job in case of each petition. So supposing the president had decided to wait, the committee could carry on with its work.
There are a number of cases, suits, that have been mounted on the back of this, including as pursued by the Chief Justice herself. And there's been commentary from left, right, center, including the Bar Council in England. Do you suspect that this was to preempt anything that could, have come out of any of those suits that are still pending, that they could have scuttled the committee's work, and that's why the committee decided to run fast with the first one?
Thompson, I'm not a political commentator. So I'm going to say that in constitutional matters, suspicions are irrelevant. Yeah. So I don't suspect. I deal with the constitutional law and the content.
The Supreme Court says that a multitude of suspicions cannot constitute proof.
It cannot constitute proof or law. So I'm going to decline to speculate on the matter of why. The president, I will say, was completely within his rights to act, and he chose to do so. Had he not acted, the committee would have had 2 more petitions pending. Okay. But now that he has removed the CJ, there's no CJ to question.
Right.
There's no justice to question.
Let me get back to where I started, Aiko, to then we look into the other matters surrounding this issue. So, Ms. Aiko, to the question I just posed to Mame, I want you to tell me if you feel that this is what actually happened, that potentially one of those suits pending could have disturbed the ongoing process, the process that was ongoing.
We are talking about fairness and procedure. I thought you said that they teach law and ethics. Here is somebody who tells us that he is going to adjourn the other petitions Sanadai and will call us when they are ready. He goes to the president, informs the president that indeed the people asked for adjournment and we have adjourned the case to the 15th of September. We will be going back. Why was there? Where is that indecent haste to rush and go and present the petition where you have told everybody there are 2 more that you intend to deal with? What is the indecent ace for? What are they trying to prevent? The ECOWAS decision or other decisions in the court? If somebody doesn't want to speculate, we will speculate. If somebody doesn't want to speculate, we will go ahead and speculate. Why? What is the rush for? What is the rush for? 1 week. As she herself put it, what would it have spoiled? If you give us 1 more week to wind up. And again, they didn't even say we are not going to grant you. So go and file immediately. What they said was that, we have all been practitioners. And I'm quoting Gabriel Puama. We have all been practitioners before. The fact that you are asked to file by a certain date, if you cannot meet it, doesn't mean that you cannot file. So just file it within a reasonable time. And then we would decide. So you are saying that there's nothing wrong when you listen to only one side. Now you are quoting things from their submission. Have you seen ours to also see what responses we gave to those things? Have you seen ours?
I would love to see that. See yours.
This is just most unfair. Everything they have done is wrong. And they are just in a hurry.
But I am not the committee. I decided myself to subject myself through 106 pages of address to read, to inform myself of the one side. But you see what addresses we cannot do is they deal with facts, even though we can be selective about the facts. So there are facts in the address that you cannot impugn. I would like to read yours.
My brother, I've been in this job
I'll lay hands on it.
40 years. I've been in this job for about 40 years. I started as a criminal lawyer and I changed because I realized that we had a right to address the court when the police prosecutors did not have the right. And I felt that what we were doing was unfair. So I left criminal practice and went to civil. You can put all sorts of things in it one way. That is what you are saying. It is when you hear the other side that you find that somebody is twisting the facts. So the mere fact that somebody has written an address doesn't mean that.
Okay, so let's not make this the subject, even though I made a small reference from it. Let's not make it the subject. And I'm careful also because when I read an address and I'm seeing records, quotations. Because they are sending to the committee, they cannot, quote what does not exist in the record because they will be found out. And we don't do that as lawyers anyway. So my question...
Lawyers address the court and they put all sorts of things there because they know the prosecutors cannot address. I'm speaking from experience.
Okay. So my question now to you is that, what happens now? But first of all, you say that you agree with Sophia Kufu that, for example, the financial impropriety leg, it was not such a weighty matter that should lead to the removal of a Chief Justice, right?
I didn't say so. You see what? You also purport to be quoting me. I did not say so. Let me take you through the process that I took them through, including those who sat at the committee. Vomawa was not there. We asked them, was there an audit? And they said yes. Did the audit raise queries? They said yes. Did the spending officer respond to those audit queries? They said yes. Was there a final management letter? They said yes. Did the final management letter refer to any setting? They said no. I have a copy of the final. If you say you have the proceedings, look at it. Audit service management letter on the accounts of the judiciary for JS Judicial Service for the period 1st January 2023 to 31st December 2023. Dated 30th July 2024. If you claim you have the full record, read it for yourself and tell me where in this management letter they said they have found anything wrong. The auditors who did the work.
Okay, so your point is that if the audit did not flag the issue, there should not be an issue. That's your point.
It means they agreed with the explanation given to them, including the travel policy and all. They agreed with it, and they never came back to it.
Okay.
It was never raised again.
Okay.
I said, I have a copy here.
Yeah, I get that. I get that. Nobody is disputing anything you have said.
Yeah, look through yours and see whether you can find anything on that.
My question to you:
the way to treat an individual?
Yeah. So it's not in controversy. So let's not get to that. My question to you is: your point is that if the auditors did not flag misuse, unlawful, expense, or unconstitutional expense, nobody should raise it again?
I am saying that when the auditors come, they look at the record. When they have issues, they raise the issues. Then they give it to the management, whoever it is who is responsible, especially the spending officer. And they ask you for your explanation. Perhaps the thing is there. They didn't see it. So then you explain to them. And once you explain to them, that ends the matter. So the fact that it was even raised in a query does not mean that is the end of the matter, because you are now given the opportunity to respond. Something you have experienced, don't you? So having responded, and they left it in the final management letter, pointing out the areas they find the judicial service didn't do well, and this one did not come out. How do you turn around? And this committee, this report was before you. I specifically asked Domelevo, who was sitting there, whether this is not a procedure. He agreed. I think he even said there's a difference between audit observation and audit query. But these days they talk about audit or observation or something.
All right.
This is what happened, and the report is there. So where is this thing coming from?
Right. So let's put the committee in perspective. From the letter to the Chief Justice, which said, in the opinion of the committee, quote, in the opinion of the committee, the travel expenses which the Chief Justice heaped on the judicial service when she traveled on holidays in September 2023, first to Tanzania with her husband and second to the United States of America with her daughter, together with the payment of per diem to the spouse and daughter of the Chief Justice, constitute unlawful expenditure of public funds. It cannot be justified in law or policy. Those acts constitute avoidable and reckless dissipation of public funds and, in the view of the committee, to have been occasioned by the overall head of the judiciary and the judicial service, whose duty it is to guard public resources allocated by the government, is caught within the spectrum of stated misbehavior. So they are saying that there's no policy allowing this. The Constitution also does not allow it. So it's both unlawful, it is also unconstitutional. You are saying once the auditor didn't make any such claims, a committee like this cannot be heard to say what they said?
Please don't trivialize it. One of the members of the Judicial Council happened to be Gabriel Scott Puama. He had always been there with them, taking all the decisions, including travel policy. I explained the last time I was here that because of the judicial independence, they also granted them financial independence and asked them to work according to what they think is best to secure their independence. And therefore, they told them that it is only the Judicial Council that can determine anything which is pertaining to them, and not necessarily the executive. Not necessarily the executive. So the travel policy was something that came out from the Judicial Council, where Puama has been serving. And he knows that there was this travel policy which allows the Chief Justice to travel with a person of her own choice, and that whatever, whatever per diem is given to her, the person is traveling with will be given half. These are not stories. They are all there. The Chief Justice's appointment letter stated clearly that she will be entitled to 2 vacations in a year. And she can choose wherever she wants to go. Her duty is to tell them that this is vacation period, I intend to travel. Then the spending officers will work, buy the ticket, do all the protocols, and then give her whatever her entitlements are. And then she uses that to travel. I am challenging them. Let anybody bring a document where the Judicial Service or Secretary said, these are your entitlements. And then the Chief Justice said, no, I will not accept it. Give me this rather. Nothing of the sort happened. And I'm saying I've gone through it twice as a Minister of Justice and Attorney General and as a High Commissioner. When I'm to travel, I don't get involved. All I tell them is that I need to travel. They work it and bring it to me. Which is why you have a spending officer who is held liable. How did they change it? With Domelevo sitting there, now saying that she being the overall head. Where has it happened before? That the President of the Republic is being held responsible for the acts of the chief directors of the various ministries because he's the overall executive. Where has it happened before?
The central point that was raised by the petitioner is that in that travel policy, it provides a limit. And it says with an emphasis that the CJ can travel with the security alone. For a foreign travel, the security alone. Then they even impeach the policy by saying that as an Article 71 office holder, it is the president, or is it the other way? No, when committees are set up to determine emoluments, it is the committee set up under Article 71 that determines what you are entitled to. And anything beyond that is unconstitutional, is unlawful. And then they quote the CJ herself in at least 2 or 3 different cases where she insists that anything beyond what has been determined by the president or parliament, president for parliament, parliament for president, and so on, is unconstitutional. And it is the reason when Abronye took the case to the Supreme Court about the spouses of presidents and vice presidents getting paid as ministers, the CJ led in that decision and said, you won't even allow, even if Parliament was approving it that way, it will not be allowed. You don't agree with them that you can't fault the committee on this?
We fault the committee. The Chichiketa brought a document on travel policy and per diems. In that travel policy, they said the people should be public officers. Then there was a footnote in which they stated that these things we have brought do not affect the judiciary because they are an independent body. He brought it and we pointed that out to him. They were all sitting in the committee, we tendered it. In fact, we allowed it to be tendered and brought it out to show them that it does not apply to the judiciary. Where they stated clearly that their terms and conditions and all those purpose of office should be determined by the council. And I'm saying Puama was a member of the council.
Okay. The committee, as we also understand through the letter, found, quote, it said, the committee states without fear or favor that the Chief Justice unjustifiably breached the provisions of Article 296A and B of the Constitution, 1992, in the way and manner that she transferred Mr. Badin. Her conduct amounted to misbehavior. The committee is of the view that the conduct of the respondent, that's the Chief Justice, falls squarely in the category of conduct described as stated misbehavior under Article 146, Clause 1 of the Constitution. The committee is of the opinion that the action and conduct of the Chief Justice falls within the meaning and category of stated misbehavior as provided under the article of the Constitution. They go ahead to talk about the appointment of justices for the Supreme Court and the manner in which she is accused of initiating it from the back door with the president instead of the known procedure with engagement of academia and all other parties, and say these are grave enough to warrant her removal. You disagree with them on these ones too?
You haven't you been a head of department before? You haven't transferred anybody? Or where you are working, you have not seen any transfers happening? When does transfer become stated misbehavior? If you are working as IT man in charge of a justice system, and a judge complains that somebody has tampered with records, and you go into the matter, do you know what happened? They brought in the National Signals Bureau. They went into the matter and were satisfied that it was this particular gentleman who should be held responsible, because he came and took away the hard copy to his office and went and tampered with it. And when the Signals Bureau went into it, their conclusion was that indeed the date in terms of time slots that is given as the date that he came and took it were all lies, and that he tampered with the record. They put the fault squarely on him. The Chief Justice only set up a committee of inquiry to go into the matter as she was wont to do. At the end of the day, the committee came to the conclusion that there was sufficient evidence before the committee that at the close of each day, those recorders, when they are not at the in the judicial service premises at the time, the court where they operate, then they share their log out credentials with others to log out for them. The committee therefore came to the conclusion that for a grave matter such as this, you have to give them the benefit of the doubt. At the end of the day, the Chief Justice agreed that you should be reinstated, except that he has decided to transfer you. What is wrong with that? Where is it defined as a stated misbehavior in the Constitution? What you are listening, if this woman was your sister, and she only transferred somebody, and you are telling me that amounts to stated misbehavior.
I need to get to my other panelists, but it was important to engage you. Hold on.
Yes.
Okay, so let me just proceed this way. So you will see that the contention was that Mr. Bading by the committee was not found to have done wrong, so he was recommended to be reinstated. And then for someone who is known to do IT work, suddenly is being transferred to do things that he was clueless about, and so on and so forth, sounded like a punishment.
It's not true.
Please hold on.
It was not true.
Please hold on.
He was asked to go and set up the e-service system, which is all IT. E-service.
Okay.
How do we serve processes electronically?
Right. So beyond Mr. Bading, there are several others, the issues of transfer. And Mr. Bading's issue, they find difficulty, even though you may see, as the Chief Justice in her testimony suggests how grave she found it and how she wanted to resolve the matter. This was the record of the day for which there was a pending matter before the General Legal Counsel, and Judge Ikwesin's lawyers needed that record to make their case at the General Legal Counsel, and somehow that record gets missing or gets tampered with. And so, the CJ2 becomes very interested in making sure that things are done, bringing in Signals Bureau, but they point out clear laws that dictate how the matter should be resolved without bringing in Signals Bureau and the alleged harassment of the officials. But beyond that, I was making the point about the several other issues, including transfer of judges, where she's accused of acting contemptuously, like not even wanting to obey orders, decisions of the courts, where some of the people had gotten a decision of the court in their favor, and she is not interested in implementing. And this Giabour lawyer, whose case was also, pending, and she uses a fiat to sort of, as she's accused, get the courts not to deal with his matters. You think all of these things are not weighty to warrant the conclusions they arrive?
Samson, I'm disappointed. I'm highly disappointed. You told us that you had gotten note of the reasons that the committee, copies of the reasons that the committee gave for arriving at the conclusion that she should be removed.
The letter.
Did you see any of those things we are talking about here? Have you seen any of them except the Frank something?
They are in the petition that was leaked long ago.
So what? When you look at Article 146, what it says is that a justice of the Superior Court or a chairman of the Regional Tribunal shall not be removed from the office except for one, stated misbehavior or incompetence, all on the grounds of inability to perform the functions of the office. So is it not for you to bring evidence to show the things you are showing that you are required to do, and which one did they accept? All the things you are talking about, did they accept it? I'm disappointed. Why are you bringing that into this conversation? They told us that this is what they have accepted, and that even amounted to stated misbehavior. Where is it defined?
Oh, they are referred to transfer, so they are referred to
I am telling you
the initiation of the appointment of Supreme Court judges.
Yeah. Please, the copy you said you have intercepted, didn't it tell us the reason? Did they add?
So thank you. Hold on there for me. Thank you. Let me come to the studio now. So Oliver, I'll begin with you. So what do you have to say vis-a-vis what Sophia Akufu is saying about the matters not being weighty enough, even if they are proving they are not weighty enough?
Thank you, Samson. I mean, first of all, let me start by the process that Article 146 itself entails and what is the responsibility on either ends of it. So we have designed a particular process that says the Council of State is in charge to make a prima facie determination whether or not the committee should go ahead. My understanding and my consistent view on prima facie means that if the allegations on their face, if proved, would amount to the removal of the Chief Justice. That's what my understanding of prima facie is. So the question then for the committee is to determine whether or not those allegations have been proved. Because it is the political body that advises the president that makes the determination to set what is the moral language and weight we should accord to the facts as alleged. So that already, once the prima facie determination has been made, what we are coming now to determine is whether or not proof exists for the allegations that have been made. That for me is my view of that. So the real determination of what should be the content or tenor of stated misbehavior, we must take that direction from the Council of State. Because I believe inherently that lawyers are not better placed, and in this case, the committee is not only made of lawyers, to judge what should be the moral temperature or the moral grounds under which a person should serve to the higher office. That decision, we commit it to the political body that the Council of State is.
Sophia Akufu was there.
Yeah, she was there. She was part of the process as well.
These were trivial, and she
was part of the process as well.
So she abstained.
In that process, she did not object to, and in fact, she was entitled to object to and entitled to write her own reasons as to why she does not take the view. She's of course no less a person. She's chairing the legal committee of the Council of State. So if you're deciding to abstain, you're taking a morally ambivalent position on the issue. But I don't want to, again, speculate about her own conduct. It's a council's decision. ultimately, not an individual. So the council have been taking the view that we have looked at these allegations. If they are proven to be true, we believe that there are grounds enough to remove the Chief Justice.
Vakufu says, even if audits, flag these issues, okay, they would normally maybe do a surcharge or disallowance, and then the person would have refunded. That's what she says in her own words. This is not enough to remove the person from office.
And the benefit of, she's a former Chief Justice. Even if she was sitting on the Supreme Court, her opinion must be weighted against that of everybody else. She forms part of the council that advises the president. And they have taken the view that this is the standard to which we want to hold the high office. She's entitled to disagree. And I don't want to even go back and forth on whether she's entitled to disagree, the other persons who disagree. In fact, those representing the Chief Justice also disagree with the committee. So for me, it is not about that in itself. But what we are consistently doing in this process is for us as a nation to determine what are the moral benchmarks by which we want to hold office holders. Now, that conversation has come up severally in connection with 146 and stated misbehavior. In the case of Jacob Opon, we decided that the fact that he refused Larry Beaming's order to change his office was sufficient misstated misbehavior because it amounted to insubordination. That tells me that if the Chief Justice then gives a command to a Supreme Court Justice to do XYZ, which is competent to do in administrative duties, and the Supreme Court Justice refuses, that is stated misbehavior.
He just referred to Jacob Opon, who was one of the first
persons removed under 146.
Under 146, he was working with the NCC as a deputy to Larry Beaming. And you are saying the basis for which he was removed under 146 was that
he refused the direction of Larry Beaming to change his office.
You are being told over and again that don't compare these offices to that of the Chief Justice, which is an arm of government.
Absolutely, I don't accept it. I absolutely cannot accept that.
No.
I cannot accept that because 146 states what is the moral basis on which we would judge the conduct of persons who are caught within the provision. So it is not that a person becomes so powerful that moral restraints that will hold other persons, their position elevates them beyond it. What are we saying?
That's
now,
okay.
Of course, my biggest concern in terms of the architecture of our public office and how we hold them to account is the fact that when we decided that those who were making payments to spouses of presidents and vice presidents was unconstitutional, there was no mechanism to bring their removal into question. It is the fact that there is no holistic application around the entire body of our public officers that is creating this disconnect that makes other people feel that everything can be negotiated out of. Everything is not that bad. It is that bad. Whenever we have taken decisions that violate the Constitution, there should never be a case that I am so important that I should not be removed. In fact, you started your take by the Deputy Prime Minister of the country. This is the second in command is the equivalent to our Vice President in many respects. Is resigning because of paying inadequate property taxes. So we as a society have then decided that everything can be massaged. This is not that bad. We have always done this in many ways. Somebody can come and beg for you. And because of this, even when we are presented with an indication that maybe the political class wants to be pushed even further, we don't go the full haul. So my position is clear. I don't want to. The question that was procedurally relevant for the committee is that are these allegations proven? The fact that they are proven is not in doubt. Now, you can disagree whether or not you think that persons who are in certain offices should be allowed a certain margin for moral irresponsibility. It's your own position. You can also decide that, in fact, for these ones, we want to hold them to the highest standards. And for which reason, even when you are found to have acted capriciously in connection with Mr. Badin in the second allegation, or on basis of whether personal dislike or resentment, we think that for your office and for who you are, you must be removed. For me, that sets the tone of what we expect of the office. Now, the reason why we have come into a situation like this is because we have a country where persistently we have made it such a case that everything, when it happens, we can decide whether or not we want to move forward with it or we don't want to move forward with it. And so many times when things like this have happened, the expectation is that people will kill it, people will deal with it in a particular manner. And for which reason, it is almost unfair that persons will be held to these standards when they have to. But I see so many instances, and perhaps those of us who are constantly in the defense of those who are the poorer sections and the weaker sections of our society, know that they don't get as much grace. In connection with the process. Now, is it proven that the Chief Justice then, in taking certain trips, acted in violation of the Constitution? Yes. What Sofa Akufo is telling us that even if it happened, we should excuse it. But that's not my place to say. The first thing we need to look at even is in terms of the code of conduct of judges and magistrates, which is telling us that judges must act in terms of propriety, way above even what the public does. That is their own code of conduct. So if this is their own view of the situation, I think that I will be in a wrong position to come and say the committee was not entitled to be able to reach the conclusions that we reached. My only hope is that other public officers, we have established mechanisms that it is not sufficient that people are hauled before the Public Accounts Committee and we laugh and jaw over it and then things are gone. If we believe that the Chief Justice of this Republic can be removed for those, then every officer that misconducts themselves in this similar manner should also be removed.
I'll go to Mame and then come to Inusa and Naneje, but I need to take a quick break. And Mame, the question I want you to be looking at is what Sofa Akufo says. Are these matters weightier enough? That we must change the Constitution to define stated misbehavior to be issues that have what she calls a gravitas, to be able to push, the head of the third arm of government out of office, and not because of some of these things. And as you find out, mostly she is sort of caught on administrative actions. Okay, she's taking administrative decisions on one point to the next, one to the next about this court thing tampering with, and she's in a hurry to get the matter resolved. She brings in Signals Bureau. They say, oh no, we don't allow this. They go and quote law that says it's not Signals Bureau that must come in. It is the High Court judge. This person, you did this to them, and so on and so forth. You went to, initiate the appointment of judges. You can't do that. You did it backdoor with the president. You can't do all of that. All of these accusations. Sofa Akufo says, this has now weakened the judiciary. Do you share that view? We'll be right back. You're welcome back. This is Newsfile, it's your most authoritative news analysis platform. We have an extended edition, so just stay put and enjoy our guests as they dissect the issues. And the difference we're trying to bring to you is not just to bring you, some cacophony, some noise. We want to stick to facts and the law. Of course, you can't avoid the politics. Some of it, dose of it, it's okay. Awin Bond says, any Ghanaian, no matter your position before, currently who in any form supports the misconduct, abuse of statutory laws, etc. by the sacked Lady CJ is automatically corrupt. Okay, so if you support, then you're automatically corrupt. We can't be jailing ordinary people for stealing files, etc. and ignore this simply because it is the CJ. It's like part of the argument that the petitioners made at a certain point. Ahmed Abbas, Sayuti, says, I wasn't surprised by the removal of the former Chief Justice because she abused her position, which was common knowledge to every Ghanaian. She should be made to refund those per diem. And I'll die on that hill. Okay. Proverbial Twitter says, so far behind the wall of defense, I have not heard anyone saying she is going to the same Accra Supreme Court, not Abuja's, for constitutional interpretation of Article 146. That for me is the surest way to undo the popular phrase, the law is the law. Big Ben says, one can't be surprised when it was made clear during their campaign that the CJ was going to be ousted when the NDC government returns to power. It only saddens me the politicization of the judiciary will only get worse from here. Abdullah Pegla Issa says, I believe that anyone who has many years to serve beyond 5 years will be endangering his or her career by taking up the CJ position because you won't last 3 months in office when NDC leaves. Hey. This one says that Justice Tokonu has joined the history of Akokosa. Both were removed, not because of corruption or incompetence, but because the President Mahama and President Nkrumah used political power to remove them. Okay, so now let me go to Mame. And Mame, someone who is attending a conference out of this country says, I'm watching you from, and I won't mention where he is, so they may identify that he's in the conference, but he's not paying attention. He says, I cannot even concentrate on my conference. Remember, Charlotte Osei was removed based on administrative lapse, such as the breach of the PPL. Remember our suit. Remember what one Supreme Court judge said, that if a judge is fond of getting drunk all the time and it comes to the attention of the authorities, will we say because it is not specifically mentioned as a grounds, he or she cannot be removed? Stated misbehavior ghost is back haunting they themselves. Okay, so this person sat in the courtroom when I was arguing the Kukubaku case about the Charlotte Osei matter, and I told the judges that you are all endangered if you don't provide rules to state what exactly is stated misbehavior, because she has breached a procurement process. Why don't you use a different way rather than remove her? Yes, Mame, were these matters too not worthy?
Thank you, Samson. Let me start with a quick comment on the separate actors in this saga. I'd like to first commend the President on having respected the Constitution and the Constitutional Court in the process. But I'd also like to commend him for having had the statesmanly prudence to refrain from speaking on the matter in public during its pendency. I mean, there were no such sensational press conferences, and no one considered interviews from his spokespersons of office or his office. I take that to mean that our leader appreciates the gravity of what he has just done. I want to comment on the removed CJ, and I wish she had shown as much deference for the Constitution in the process and not held the press conference that she held. I think whatever the strength of her concerns, the use of the press conference to air them was not the appropriate forum, and as the head of the judiciary, she should have demonstrated faith in the Constitutional Court and limited her public engagement to the court processes. So, with respect to what's...
Will you be surprised, Mame? Will you be surprised that what you just said was actually used against her in the address of the petitioner? They used it against her, that she went public to say things and try to get public sympathy against the committee, and they quote things where she herself is heard saying that the committee has been generous to her, and they say she didn't tell the public all of that. Then they say the committee said it was an inquiry, but she told the public that the committee disagrees that it was an inquiry, when the committee had actually said it was an inquiry. And they say all sorts of things. Some of them, I think, a bit, you may say trivial, that she got angry, stormed out of the place, and so on and so forth.
I think, as I said earlier, if everybody had respected the income requirements, there would be a different tenor to the process. And the former Chief Justice, did not lead well on that front. That should not have been the forum. In respect of what Justice Sophia Kufu said, I understand her to mean that, I understand her not to mean that a CJ should be able to behave improperly without repercussions, but that the constitutional processes upon which the distribution of power rests in our state are so weighty and they so reverberate through the legal order that we must hasten slowly to trigger them. In that, she is right. The appointment and removal of the heads of the arms of government are constitutionally foundational matters. Removing a tumor can save your life, but it might also leave you paralyzed, or you must have to learn how to speak again, or learn how to use your arm again. So we should be mindful that even a good outcome in these kinds of foundational matters leave unintended consequences and have impact that we should be very mindful about intentionally addressing. Where I disagree respectfully with my lady is that the matters established are not weighty enough to merit removal. As Oliver said, the committee's question was not, are they weighty enough to merit removal? It was, are they proved? That question, are they weighty enough, was put to the Council of State. And the Council of State said yes. I have issues with how the Council of State came to have the say in this matter, because the Constitution originally does not include the Council of State, but that's a separate matter for a separate day. I think that even aside from the Council of State having said yes, I personally think that the legitimacy of the legal order rests on the people's perception of the judiciary. And therefore, judges have a duty to hold themselves to the highest standards of integrity. Virtue signaling is really important for the maintenance of a constitutional order. It's as important as the use of the actual judicial power. So, for instance, when you are studying for an exam, that you get a certain comfort from being advised by the best student in the subject. So much so that when contrary advice is given by the worst student in the subject, even when that advice sounds more correct to your ears, you are very hesitant to take it. And that is the role of the personal conduct of a judge on the legitimacy of a system. So, if it is really important that the head of the judiciary virtue signals. There is, after all, no connection between the legal and philosophical soundness of a judge's decision and the moves they were making in a club the previous Friday. But none of us would want to walk into a courtroom and find the super flexible dancer from the club last Friday behind the gavel. In like manner, the CJ should be held to the highest standards. And she is human. Everybody is. There will be errors. There will be mistakes. But they should be such that they should be open to an interpretation of good faith error. So if the Council of State has found that these matters are weighty enough to remove a CJ over, I think, like Oliver says, it is a statement about what we expect the standards of integrity of our public officers to be. And I think the committee's job was not to investigate whether the council was right to say so or not.
For Justice Sophia Kufu, she had been consistent, we will say, because she doesn't agree that there should even have been a prima facie in the first place. And then she comes now, after it was done, we get to know that she goes to testify, for the Chief Justice. She, together with other friends, go to testify for the Chief Justice. So her position is one of consistency.
And this is one of the things I admire about Justice Akufo. She is consistent. If she takes a position, she thinks it through and she stands by it. And I respect that in a judge.
Right.
I do, however, disagree on this in this instance.
The question people are asking, the question people are asking, which I want to ask you is she not entitled to change her mind? If you say that in Charlotte Osei's case, she's the one who found prima facie, and it was about procurement. You say this one, for example, the financial impropriety charge. It is a matter for audit and the finance people, and even if it was flagged, she could just repay or refund and move on, instead of using that to remove her. Is she not entitled to change her mind that in this case, I found prima facie and it led to the removal of Charlotte Osei, but now I reflect. And you see that anytime she talks, she's reflecting on Article 146. That something ought to be done.
I'm a legal theorist, and I would be remiss to say a person must stand by a position they took even after they've evolved. So I don't necessarily find it odd that I have taken positions that I have later resiled from. I do think that intellectual honesty requires you to admit that you have resiled from a position rather than present it as a position you've always had. So if Justice Akufo has reflected further and has changed her mind, I'm not sure why she's not entitled to do so. Any more than I don't know why I wouldn't be allowed to disagree with her on this one.
So it would be unfair for those who suggest that she's being dishonest.
I mean, to the extent that she admits that she has taken a position on reflection and has results from the original position, I think the whole point, I mean, there was a time when slavery was right, and then there's a time when we soundly saw that it was wrong. The problem is if we pretend we never had slavery, we never thought it was right. So I haven't myself read Justice Akufo's statement. I cannot say, therefore, whether it is it falls in the line of the methodology I think an intellectual should use to evolve.
Okay.
But I can't say that the fact of evolution is not wrong.
All right.
Whether this particular instance meets it or not, I am not in a position to say because I haven't actually read the statement.
She actually uses the term de minimis. The courts do not concern themselves with trifles. This is what it was. But this thing that people are bringing up is the reason I remember that she used the Latin expression de minimis. That she's been removed as CJ, but not removed as a justice of the Supreme Court. What do you say to it?
I think the removal of a CJ for stated misbehavior would have to meet a threshold of stated misbehavior for a Supreme Court judge. So, first of all, I have seen the deed. The president has removed her as both, but I think it would be odd to say that misbehavior that meets the threshold for the removal of the Chief Justice somehow does not meet the threshold of misconduct for a Supreme Court judge. The specific instances are not instances, are administrative things. So they're not matters that a Supreme Court judge ordinarily has to deal with. But the question I would ask is, if we were to say that it was not sufficient for removal, right? These are not weighty matters. Then if other people come before the courts on financial misconduct matters, misappropriation, embezzlement, and so on, would we be able to impanel a Chief Justice who has been removed from Chief Justicing for similar conduct to sit on the matter of the ordinary citizen, whether it's a civil matter or a criminal prosecution, as sometimes financial misappropriation can lead to? So it seems to me difficult to retain the legitimacy of the institution and the Supreme Court as a panel to have a Chief Justice who has been removed for stated misbehavior from the position of Chief Justice as a member of the panel.
All right, let me come to Enos of Seni here. Even though I say this sounds de minimis, I remember initially when the matter came.
I make one quick comment before you move on.
Yes.
I wanted to comment. I said I wanted to comment on all of the actors. I wanted to comment on the petitioners.
Okay.
And I want to commend them both for their courage and their proactivity. I have said time and again that a constitution is an agreement between the people, their agents, and the state, and that the people who are not ready to check or question or supervise their agents are not ready to trigger for self-government. You know, it takes courage to trigger one of the weightiest and most far-reaching processes on the Constitution. And however it plays out, if you're a petitioner, you will be a hero in some quarters and a villain in others forever. It takes courage and a genuine belief in the cause to put yourself in that position. So for showing that we have such valiant ones among us, we must collectively be grateful. I do wonder, however, how they got access to all the information and evidence in their petitions. I think some of the information is such, by its nature, it should not be available to people outside of the judiciary. So I'm very curious how they came by this information. And I think I ask these questions not to cast aspersions on their motivations. You know, I'm personally unmoved by the continuous refrain of politically motivated, it's politically motivated. Very much about public life is politically motivated. The choice of a president, even a school prefect, is politically motivated.
Right. Justice Akufo says that now every judge or chief justice is fair game.
I think accountability, I think, as I said, a constitutional order is a delegation of authority from the people to their agents. So there should be nobody who's unaccountable in that setup. The accountability mechanism should not be so weak as to make it take up 3/4 of the time of anybody in the position to be defending themselves. but there should be at base an understanding that you are occupying a supervised position, and you ought to report and give account when you're asked to. So I don't have a problem with the idea that the judiciary should feel accountable.
Okay.
Independence can, at its extreme, become imperviousness, which is bad. However, and this is where I think her concern is really valid. Whatever the weight of this decision, it will shake at least one judge's confidence in their independence. And so while it improves the accountability of the judiciary, it may create in the judiciary some fear of interference or intervention.
All right.
And so we must intentionally take steps to reassure the judiciary that the accountability mechanisms are accountability, not persecution mechanisms.
Thank you. So, Ines Ofseni and you and Anabafo. So, maybe briefly about that. In 90, the GBA Justice Abam case, 96, thereabouts, 95, 96, where Pega delivered himself, which seems to put this matter to rest, that once you are removed as CJ, it's done deal.
Yeah.
Is that the position you share?
Exactly. I mean, because if you look at Article 146, it's on the removal of justices of the Superior Court of Judicature. And you must be a justice of the Superior Court of Judicature before you become a Chief Justice. And so the position is coterminous. Okay, so I mean, to have brought yourself, and if you read Ajechum and the Attorney General, it's clearly that if the removal process involves the removal of a Chief Justice, the competence also extends to competence in administrative work. And so clearly, I mean, you'll be left no doubt that if you lose that position as Chief Justice, you invariably lose your position as Justice of the Superior Court of Judicature.
You share the same view?
Yes, I do.
Okay.
Yes,
so we
but let me say that yes. I'm actually persuaded by the submission of Dr. Mami Bensabun. So when she says that justices of the Superior Court of Judicature or judges in general must be held to the highest standard of proper human conduct in the administration of justice. That is the way you restore confidence of the people and trust of the people in the judiciary. That look, nothing goes. That they must be alive to their responsibility. That the people do not endorse judicial impunity. The judges must be held accountable. That abuse of office cannot be tolerated. And judges must know that having been elevated to that position, there is an equally a huge responsibility placed on their shoulders.
But if you look at this case on the whole, are their discretion not fettered by this kind of thing? Fettered, not in the positive, in a negative sense, that a CJ will be careful, because however the decision they take administratively, somebody will be aggrieved, and that may be used against them.
So that's where rules and procedures come in. That's where they come in. Is it consistent with the rules? Have I taken a decision to circumvent the rules? Why have I circumvented the rules? Why have I circumvented the procedure?
There's a travel policy. She's not the first. A travel policy of 2019 that they have all used. Okay? But I suppose those who went to testify for her testify to the effect that it's a travel policy we have all been using. And if they use, and it says, if you are traveling outside of the country, a foreign travel, it is with your security alone. But they decided to replace the security with somebody else that they are comfortable with. Suddenly, she uses it, and she is in trouble.
When has repeated mistakes been considered as experience? So if you have been doing that and it's wrong, it's wrong. The fact that you have been doing it doesn't validate what you have been doing. You get it? I mean, if an ordinary public servant had done that, do such a type of servant.
As a Chief Justice, you will transfer judges for one reason or the other. As a Chief Justice, you will fix cases. So here she's accused, what's the name? SAR. There was a delay or she has said that they can't file a particular application here in Accra, it has to go to Koforidua, and Afenyo Makin brings his case the same day, within 2 hours, she has empaneled the court. Meanwhile, we say we want speed. And she says she was doing this in respect of the election petition rules that she was championing for speed. So if they bring a matter as sensitive as that from Parliament, and within 2 hours, the CJ is able to constitute a panel, shouldn't she be praised for it rather than now be crucified for that decision?
But how does an abuse of office of a justice of the Superior Court of Judicature manifest itself? How does it manifest itself? This is a transfer procedure. If there are no legitimate grounds on which to transfer a judge, or if the judge believes that by virtue of the case he's handling, or you have an interest in the case, that's why you've transferred him or her, that you found misconduct. I mean, how does it manifest itself? How do you expect the generality of Ghanaians to understand how a case can be expeditiously heard within 5 hours? Okay? When another case has not even been programmed for hearing for for the whole term of Parliament. How do you explain that way? So these are matters, and again coming back to what Mami said, these are the matters that oblige us as Ghanaians to hold justices to the highest standard of proper human conduct. Because, you see, justice must not only be seen to be done, but it must be manifestly be seen to be done. Now, this case, and I heard you referring copiously to the petition and addresses and whatnot, I have no qualms with what you are doing because the matter has been pronounced upon.
That's right.
Okay. Now, see, when you look at the crafting and design, the architecture of the Constitution from 1969, it appears to me that the moral compass of the people of Ghana with regards to Article 146 was vested in some institutions. That's why we were asked not to pry into what those institutions were doing. Now, it appears to me that the policy rationale for the in-camera hearing has been under serious challenge and attack in the matter of the Chief Justice. And we don't know where this will lead us to. Because when you did the case of Loretta Lamte, we believed that the Chief Justice, in determining that a prima facie case had been done, had acted bona fide. We also believed that the committee that recommended the removal of Loretta Lamte had reasons to believe that she was a person otherwise unfit to occupy that office. We never questioned the rationale. Because the moral compass was vested in the committee. The standards vested in the committee. Just like Shaman was saying, just like the case of Larabimi's assistant. Insubordination. The committee set up under Article 146 came to the conclusion that the insubordination exhibited by the subordinate of Larabimi was weighty enough to constitute misbehavior. Today, we are importing de minimis, importing triviality, and challenging the moral compass of a committee established under Article 146. And so, we are removing the veneer. And this is not only dangerous, but might lead us into uncharted waters.
You're still here on Newsfile. This is your most authoritative news analysis platform. And here on Newsfile, we put Ghana first. And we programmed it in a way that you will learn and be edified at the end. Now, let me bring on Nanaje Bafowa. So, what's your take on the conclusions, the substance that have led to the removal of the CJ? And do you also join that argument that she's removed as CJ, but not as a justice of the Supreme Court, as the letter from the presidency said, removed from both, and some have indicted that.
Thompson, standards are predetermined. They are not ad hoc. And so if we are going to hold our Chief Justice and Justices of the Superior Court to standards, there should be a set standard which are predetermined or predefined. Thompson, what is stated misbehavior is still not known. Here is the case where I think that my colleagues have been confusing embezzlement and so on and so forth. How do you say this is embezzlement? In the case where the Chief Justice is not a spending officer, there's a procedure. She herself has to apply for funds to be disbursed to her. There's a procedure by which that application goes to. The people in the chain, right, have responded to audit query. And the auditors found the explanation acceptable. How do you call this embezzlement? By no stretch of imagination, you can't call this embezzlement. In any event, what is the procedure for determining impropriety of expenditure in the public sector? That procedure is the audit by the Auditor General. And the Auditor General found no wrong with this subsequent to the management explanation to the queries that were raised. And so where is the wrongdoing? What is the basis for this? In Boyfield versus NTAC, it is clear, the law is clear. When an enactment makes provision for a procedure for taking a step, it is that procedure alone which should be complied with. And in the public space, it is the Auditor General whose work it is to establish propriety or otherwise of an expenditure. And so where is the wrongdoing? How does she commit an error for applying and going through procedure to obtain expenses? I think that the decision is so embarrassing, to say the least. And so, yes, let's hold our public office holders, let's hold our judges, let's hold our Chief Justice to a higher standard, but the standard ought to be defined. Now, in the case of the transfer, how do you say that a Chief Justice who has been given the discretion under our law to transfer cases, to allocate cases, to assign cases to a judge, commits an offense for doing so? How? And then you say that, look, I'm not surprised that they said that the transfer of the staff of the judicial service is contrary to Article 296, Clause A and B. Because they can't even point to an established regulation that frowns on the transfer. In the absence of a regulation that frowns on the transfer, how do you say that the exercise of that power is arbitrary, is unfair, is capricious?
They find, what shall I say? They don't say the mere transfer or the mere assignment. For example, when they brought in the petitioner himself and the cases he was involved in, you know, at a point, the petitioner had got the Supreme Court to prohibit, you know, Justice Stockton, who was not a Supreme Court judge then, to prohibit her from handling the petitioner's case. And then she becomes Chief Justice and still has to do the assignment because that's her job. And she does them, and they say that they find ways to say that the way she did the assignment is like she looked for favorable judges who give judgments the way she had also done against the petitioner. You know, that's how they weave it around.
So the findings of the committee is even an affront to judicial independence. The independence of judges to determine cases outside of any influence. Samson, when the CJ assigns a case to a judge, because of the independence nature of the judiciary, right, is expected to determine the case pursuant to his judicial oath without any influence or, any sort of pressure. And so if we don't have such confidence in judges and think that they can all be influenced, then where do we find ourselves? So the finding itself is an affront to judicial independence.
Okay, so now we have to be sure if there's a particular finding about this, about transfer of cases and assignment of cases, like Aikoto had cautioned earlier. But you see, as I sit here, I'm asking myself, I was asking Inu Safuseni questions, and she was nodding in agreement and speaking in agreement that, the way Charlotte Osei's process went. Do you remember how they vehemently protested, that process? But now, because it has happened the other way, he can use that to rationalize what has happened to the CJ.
Look, you see, I wouldn't want to do false equivalence. I don't want to do false equivalence. If Charlotte Osei was wrong yesterday, it doesn't make what the CJ has gone through right. We have to be careful. If it is scores they are settling, because they keep making reference to Charlotte Osei, if it is scores, let everybody know that we are settling scores. It looks like that is what they want to do. If it is scores that the MPP did it to Charlotte Osei, so we also want to do it to the Chief Justice, then we know it is score settling. But Samson, I don't want to engage in score settling.
Okay.
Samson, I want us to move on as a country where our democracy becomes stronger. Right? You see, everything points to the fact that what has happened is wrong. Mr. Ayukoyotu, my honorable senior, pointed to evidence that shows that the allegations have already been dealt with by the Auditor General in respect of the financial impropriety. Deliberately, they keep making reference to embezzlement. This cannot be embezzlement.
I don't think embezzlement is the word that has featured
anywhere.
It's financial impropriety. It's financial impropriety.
With the greatest respect, I use embezzlement as an example of criminal offenses that proceed from financial misappropriation.
Okay, okay. Thank you.
Then you compared apples with oranges. I'm saying that this is financial.
I did not bring it up this
Mami,
as a matter of something.
Mami, when you were speaking,
so Mami, please do let us.
This is financial impropriety.
Absolutely.
And the Auditor General is the institution. The Auditor General is the person mandated to deal with it. The Auditor General has dealt with it. Can this be a ground for the removal of the Chief Justice? Is the committee an audit committee? In any event, the committee, look, I agree with Mr.
So the committee didn't seek to do an audit. What they sought to do was to understand the policy, the policy that was relied on.
The interruption has not allowed me to flow, and I don't think you've been fair to me in that regard. Please, let me put that on record.
I think when you misquote me and misassign things to me, I'm entitled to correct it. I did not accuse the CJ of embezzlement. I did not accuse the CJ of embezzlement. It in response to a question whether she
remains
power judge, and I merely said ordinary citizens may be brought before the Supreme Court for embezzlement. I did not say the CJ had embezzled.
The President's power.
If you're going to quote me, please do me
that with the Council of State.
Quoting me correctly.
Mami, thank you. Thank you for your intervention. You set the record straight in that regard. Nana, go on.
The President's power to look into this matter together with the Council of State was invoked by the petition. The committee's power to look into this was invoked by the president's determination of the existence of a prima facie case. And the president forwarded, supposedly, the prima facie case composition of the petition to the committee to look into it. That is where the committee's jurisdiction commenced. Now, instead of dealing with everything and reporting to the president, you have dealt with just one. And now you have told the president you are going to deal with the rest. How are you going to deal with the rest? That tells you the poor nature of the work that has been done by the committee.
So the statement by the committee, they say that they will report on the other two. I don't know whether the report means they are going to continue to sit on the other two.
That tells you the poor nature of it. It tells you that they didn't do a comprehensive work because the prima facie invoked their jurisdiction to deal with the prima facie part of the complaint before them. Now, we don't have a complete work, and they are going to report. Report how? Look, my brother, there's something we need to appreciate. People have said that, yes, the president has done a very good work because Article 146 has been complied with. Article 146 is not in isolation. Article 146, by implication, reference other provisions of our laws that must be complied with. Right? When it comes to prima facie determination, it is not in isolation. Prima facie is not defined in the Constitution. Okay. Prima facie is defined in the Evidence Act. It tells you the nature and effect of the prima facie. And so you cannot tick the box in Article 146 and not tick the box in the Evidence Act. Then when it comes to the hearing itself, you need to comply with the rules of evidence. The rules of fair hearing, also in the Constitution, particularly Article 23 and 296 of the Constitution, were all these complied with. When the Chief Justice in the process feels aggrieved by one step or the other, she has every right to seek redress in court, which is why she went to court under Article 1, Clause 2 of the Constitution.
Okay.
You see, Samson, when the Chief Justice invokes the jurisdiction, the human rights jurisdiction of our court, and she's told that the court doesn't have jurisdiction, Samson, when you put all these things together, will you say the Chief Justice has been granted justice? No, the whole system was very unfair to her, and my concern is going forward. We are done with this. I think that we should be very interested in building a stronger constitution.
All right. Thank you. Thank you, Nana.